Hi, very good morning. This is a Supreme Court judgment. Citation is MITC Rolling Mills Private Limited versus Renuka Realtors. Uh, Commercial Courts Act. The act is Commercial Courts Act. Issue before the Supreme Court was whether order rejecting the plaint, because they did not go for mediation. So that order was rejected by the district court. They appealed to the High Court. High Court rejected, saying this appeal is not maintainable under Section 13(1)(a). So the issue before the Supreme Court was whether order rejecting the plaint is appealable under Section 13(1)(a) of the Act or not. That was the issue. Facts of the case: MITC initiated a commercial suit before district court for recovery of a certain sum on the ground of failure to make payment for the supplies made by them. RR, that is Renuka Realtors, the respondent, filed an application seeking rejection of the plaint on the ground that MITC did not undertake mandatory pre-institution mediation under Section 12(a) of the CCA. So district court accepted it. You must have gone for mediation first before coming to us. Since you did not go for mediation, your plaint is rejected. That is what the district court said and rejected the plaint. Then MITC preferred appeal to the High Court against the rejection order. High Court held that the order rejecting the plaint is not appealable before them. It is not one of the orders specified as appealable to High Court under Order 43 of CPC. Against this order, MITC preferred appeal to Supreme Court. Then Supreme Court considered the case. Supreme Court said there cannot be any two views that the order rejecting the plaint is a decree under Section 2(2) of CPC. Thus, a decree passed by District Commercial Court would ordinarily be appealable to High Court. Then Supreme Court explained Section 13(1)(a) of the Commercial Courts Act. It said that 13(1)(a) is in two parts. One is main part, another is proviso. The main provision contemplates appeals against judgments and orders. Proviso operates as an exception. Hence, the proviso must be construed harmoniously with the main provision and not in derogation thereof. Supreme Court held where the language of the main provision is plain and unambiguous, the proviso cannot be invoked to curtail or whittle down the scope of the principal enactment unless where such exclusion is clearly and expressly contemplated. So if it is not contemplated, you cannot apply the proviso and say you can take away the main proviso, the intention of the main proviso. The proviso merely restricts appeal against interlocutory orders to those specifically enumerated under Order 43 of CPC and Section 37 Arbitration and Conciliation Act. Consequently, only such interlocutory orders as are expressly specified therein, that is in Order 43 and Section 37, would be amenable to appeal under the proviso. Orders not so enumerated, it would not fall within the restricted fold of the proviso. So Supreme Court said the plaintiff aggrieved by the order rejecting the plaint cannot be left remediless or compelled to institute a fresh suit. Saying this, Supreme Court quashed the order of the High Court and restored the appeal back to High Court to hear the matter on merits. That is what Supreme Court did. Thank you very much. Have a great and wonderful day.